Okay, now that we're all here, it's 4:01. I will call the meeting to order. First item, and this is a special meeting, so remember everyone that we can only discuss the topics listed on this agenda. We can't deviate. So, the first item on the agenda is discussion of legislation, enforcement action process, and legislation impacting Ethics Commission. Rebecca, take it away.
Okay, good afternoon, everybody. Um, so we just wrapped up testifying on another bill. Thankfully, it was short and we were able to get back here. But let's talk about the two bills in the memo that you guys got. It was somewhat short notice getting it to you guys earlier this morning. But there is a hearing on House Bill 1360 and House Bill 1505 that have been set for tomorrow morning. As I talk about we can talk about House Bill 1360 first. This is the commission's bill. We've been talking about it. I tried to go back and look in our meeting minutes how long we have been talking about the process of 1360, and I think it was August that we first talked about it. It maybe was the September meeting that we first presented it to the commission, but tomorrow is the hearing on that bill to transition the complaint process that is outlined in 5466 to more of an enforcement action process. We have some goals that we have with that, and honestly, I was going to do a brief run through of the testimony, but I don't have it in front of me, and Logan does. Of course he does. Just like that. So we kind of outlined in the testimony that we will submit for 1360 tomorrow. I will testify on 1360 tomorrow. If there are any questions about legal questions, we anticipate some First Amendment questions with confidentiality. Logan will handle those. Chair Anderson has a scheduling conflict for tomorrow morning, so he won't be able to be there. And so he has asked Commissioner Sagsbeen to provide testimony on behalf of the commissioners tomorrow from Arizona via Zoom. But for my testimony tomorrow, I will focus on what are the goals and how changing this process helps meet those goals. Number one is just that we're going to take that enforcement process and it's going to first address concerns through education and then with settlement or being able to close something. So it's kind of a different regulatory process than what we currently have. We don't have the ability to do that now. Goal 2 is to reduce red tape. Goal 3 is that our enforcement process bolsters due process. It allows more opportunities for the respondent to interact with the commissioners, and it allows that individual to speak publicly or defend him or herself publicly. And then goal 4 is that it's going to address ethics concerns in an efficient way, meaning that we can effectively and efficiently address those things. So that is 1360. We have ran through 1360 several times. And so we don't need any action from the commission on 1360, but just to let you know the kind of the overview. I think Murray wanted to speak briefly about what he plans on discussing tomorrow morning, just kind of in an overview as he speaks on behalf of the commission. Murray, do you want to do that now or no? Oh, you're muted. Murray, you're muted.
Give me a moment. My draft is hidden someplace.
Okay.
If it's okay with the commission, I would just like to testify as a new person to the board about what I observe based on the experience that I've had in state government for several decades. And I want to initially mention that the term complainant is used throughout the legislation, which suggests an adversarial criminal type of process that is really really doesn't help the process any. And so that term should be taken out. Also, the current law states that the complainant is involved in the process in the initial stages. And I just think that this is really quite unusual, because a complainant could file a complaint to gain leverage over a respondent, such as adverse publicity or offering to withdraw a complaint if certain action is taken. And also during the initial stage, if the complainant is involved, that kind of converts the executive director into a mediator, which I think is an inappropriate role during the investigation process. And this mediation stage appears to greatly extend the enforcement process for many months. And we've heard complaints about the process taking too long. And so I'd like to make a recommendation generally that once an individual submits information to the Ethics Commission concerning an alleged violation, that individual should no longer be involved in the enforcement process. And number two, currently the law includes what criminal terminology, which I suggest the term complaint and complainant should be taken out. And the third part of it is that under the current law, the commission must refer a complaint to a law enforcement agency if there's an allegation of criminal conduct. From a practical perspective, law enforcement agencies might not be willing to prosecute what they may consider to be a minor violation of the law. Let's say that a lobbyist gives a public official a dinner at a very expensive dinner and a bottle of wine, and it comes to $200. Take that complaint to a state's attorney. They might say, I'm prosecuting somebody that robbed a bank for $100,000. I'm not worried about a $200 ethics complaint. So I'm suggesting that the commission should not be required to refer all suspected criminal conduct to a law enforcement agency. Instead, the commission should have the discretion to refer egregious cases to a law enforcement agency. And another is the investigation process, that respondents and others may delay or even frustrate the investigation process by refusing to respond to the commission's request for information. And a recommendation would be that the legislature should expressly authorize the commission to compel the production of information needed for an investigation. And I just also finally said that I've read the enforcement process in the law multiple times, and I'm still confused, because it's so cumbersome that this needs to be streamlined. At the same time, it protects the due process rights of the responded. And if it's okay with you, I would like to, as just a new person, express my concerns about the process. I'll do it if you authorize me or want me to. I won't if you don't.
I think it sounds good, Mary. So I would like you to do that for us if you wouldn't mind.
Yeah, I agree with that.
I agree too, and we have had the issue of people not providing us information already. So this should be streamlined. Yes.
Yeah, I agree too. And Murray, I thank you for making it clearer as a newer member. You've articulated it well.
Well, the other thing that I did is that I worked with Logan and Rebecca about a hearing process. If once it comes to the hearing stage in front of the commission, and it doesn't flow very well under the current law. So I'll try to do my best tomorrow. So
Thank you for
Thank
that,
you.
Murray. We appreciate it.
okay.
All right, so with that, are we good? Dave, am I good to move to House Bill 1505?
Yes, please.
Okay, so you will all see House Bill 1505. It's attachment 2 of the materials for the meeting today. This bill has 5 different sections. I'm going to walk you through just briefly what those sections do, and then what we have is kind of information for the commission, and then we can have a discussion about it. So, Section 1 of House Bill 1505. This creates, they use the word immunity for, it's actually on page 2, the substantial changes are on page 2 of the bill. It uses the word immunity. It creates immunity for legislators who disclose a conflict of interest. They use the word a personal or private interest. That is from the legislative rules. But what that does is that creates immunity from criminal prosecution under a specific section, which is North Dakota Century Code 12.1, 1302. But it's conditioned on 3 things being in place: that the legislature discloses that personal or private interest, or what we call a conflict of interest. And that the official action is limited to a vote on a measure, so it doesn't extend to other actions by a legislator, and that the individual who is doing this is a member of the Legislative Assembly at the time. So that is the essence of Section 1. Section 2 creates what we call a more general immunity from criminal prosecution for legislators, but then it also creates an affirmative defense. So you will specifically see the Ethics Commission mentioned in the Section 2 of that affirmative defense. It says currently that if a legislator relies upon informal advice of a staff member of the Ethics Commission, that that individual who is a legislator can then use this as an affirmative defense in a criminal prosecution. That is the current state on subsection 2 of Section 2. Section 3 affects the enforcement process. This allows, in its current form, allows the executive director to close a matter at any time during the enforcement process. Section 4, this Section 4 actually is identical language to what the commission has in House Bill 1360. This outlines a 30-day timeline for appeals, and it creates a catch-all venue in Burleigh County or another district which has a substantial part of the alleged violation. Section 5 has probably the most significant changes besides the immunity provisions. Section 5 amends the confidentiality of the enforcement process. Specifically, on page 3, line 12, it specifically limits the applicability of the confidentiality provisions to information when in the possession of the commission. And it then further outlines specific disclosures for state employees that are allowed when a state employee has a complaint or an enforcement action filed against them. And it discusses how those state employees can disclose particular information. What I want to share with the commission is that General Counsel Carpenter and myself, we have extensively reviewed House Bill 1505 over the past few weeks. Based upon that review, we do have several concerns related to the bill. Some of those concerns appear to be unintended consequences or just based on a lack of information. I have in the memo to the commission the concerns that are just kind of noted. These are a general overview. And then the more thorough discussion is in your attachment 3, which is a more detailed, what I would say, a more detailed list of concerns that we have related to House Bill 1505. As far as the overview, where we have concerns is that, and I actually just found a typo in my memo to you guys. I do not like when that happens, but it allows legislators to rely on informal guidance, or informal advice from Ethics Commission staff. We believe and we think that that is a little bit too loose. Not that they should be able to not rely on something that comes from the commission, but just that this needs to be done in writing. And so we have a suggestion for changing how that is done. This is too broad. It could create possible evidentiary issues at trial. So we would recommend that this language be changed to written guidance from the executive director that is in accordance with the commission's informal guidance rule, which the commission has been talking about for the last few months. The second big concern that we have is that it has the executive director closing a matter. That authority should not lie with somebody who is an employee or appointed by the commission, but should lie with the individuals who are appointed by the governor, Senate Majority Leader, and Senate Minority Leader. That is the whole point of having commissioners. So we suggest that language be included, that the commission at any time during an enforcement action may settle or close a matter, and that settlement may include the issuance of an advisory opinion or informal guidance pursuant to the commission's rules. So I think that this is a good section, that the commission has the direction that they can close something if they can reach a settlement or if there is education that's provided. But the way that 1505 is currently written, it gives entirely too much authority to the executive director that should lie with the commission. That is what General Counsel Carpenter and I have kind of come up with. The other big one is that the confidentiality portions of 1505, we would suggest that we align these same confidentiality portions of 1505 with the current confidentiality portions of 1360. The language of 1360 has been discussed with many interested parties. This language, we feel like this could potentially create loopholes. There is a interpreting what it means by that the following information is confidential when in the possession of the commission. There are many interpretations that could come to that. And one of them could be that if a document goes outside the possession of the Ethics Commission, now it is no longer confidential. Well, as the commission knows, commission staff send out letters frequently to other state agencies. And so if this were to be interpreted in that way, then what could happen is that other state agencies would be required or could produce documents for the public that are related to Ethics Commission investigations. Some of those communications go out. They are then held by other entities. Currently, the confidentiality attaches to that document and it stays. This could potentially create a very significant loophole in that confidentiality. We have also concerns about whether that would be permissible under the First Amendment if you opened it up in that odd manner.
Oh, yes.
Yes, okay. So again, we have some concerns about 1505. If you look in attachment 3, we have those fairly detailed what the concerns are. As drafted, based on our review, we recommend that the commission oppose House Bill 1505. However, commission staff have been working on draft amendments to alleviate those concerns that we just discussed. And those amendments that we are working on, they are certainly not final, would certainly be in the spirit of fixing the issues that are outlined, that I just discussed now, and that are more specifically outlined for the commission in attachment 3, which is the comparison of 1505 to 1360. So with that, the bill, if we did have those amendments, and we were able to introduce that amendment, or an amendment was introduced, this bill really then becomes a companion to House Bill 1360, and they can work together. So does the commission have any questions on House Bill 1505?
Yes. Who drafted this? Who the legislative, well, let me just ask, who drafted this bill?
1505, Ron?
Yeah,
I believe it was drafted by Legislative Council, and it was introduced by LaFleur and Hogue.
okay, did
And
they,
what was that?
did they consult with you at all?
On the drafting of 1505, they did not. But since
Okay.
it's been drafted, we've had discussions regarding our concerns, and those have
Okay.
gone well.
Is that a little odd that they didn't consult with you or
Ron,
with us?
let me rephrase. I shouldn't say that they didn't consult with us. They told us they were drafting something, but didn't.
Want to get it introduced.
Yeah, they
before the
wanted.
deadline.
Yep, they wanted to get it introduced before the deadline.
Okay. Yeah, it just seems to me a little odd that they wouldn't consult with you. And I don't want to use the word bypass, but apparently that seems to be what they did, because there's too many concerns here that we have that they should have brought to your attention. But it's too late now. It is what it is.
Ron, you're correct. It is what it is. I will tell you that I don't want to give the impression that they weren't working with us by any means. I do think that they were. I think they just got it filed by the deadline, and then we
Okay.
talked about it after it was filed. So I certainly didn't feel that they were trying to bypass us.
No,
Not at all.
we were informed when it was filed.
Yep.
It was there.
Okay,
so-
otherwise you would scold them, right?
Probably. I don't know if I'd scold, but certainly ask why.
Yeah. Okay. Well, I
Any
don't
other
have any.
questions?
I'll just say that with your input now, I don't have a problem as long as, you know, Rebecca and Logan have the input and it doesn't go too far without our commission's input.
So Ron, let me kind of give you an overview of, we shared our concerns on House Bill 1505, and they listened and they understood those. And so they're willing to work with us on a proposed amendment. And so it's just finalizing the language of that and getting it put together. But you know, provided the concerns that we've outlined to the commission, all of those have been shared with Leader LaFour.
And understood.
And understood, definitely.
Okay.
Any other questions from any of the other commissioners?
Yes. And y'all bear with me as your non-lawyer. In the section on 1505, 1 and 2 sections, that those words creates immunity. Isn't that kind of like, I don't know, it raised red flags for me. What are they trying to do here? Or am I misinterpreting how this is, what this is and what it means?
Cindy, I might have Logan answer your question.
I can answer that, Cindy. The way I read it is putting into statute that if a legislator follows essentially the commission's rules by following the legislative rules, they're following the law, they should not be prosecuted for that. And that's why Rebecca and I both don't really have a problem with that concept, because yes, you should be following the law and your legislative rules. So this just puts into statute that yes, if you're doing that, you're good. So you shouldn't be prosecuted for it. And that's why we're comfortable with.
Oh, okay,
The-
okay.
But-
Okay, so
and Cindy-
if they follow the process, either one or however, okay, but
Yes.
then are those processes clear enough?
So that's the concern, Cindy, that we're working. We've had those conversations where
Okay,
it references a staff member of the commission. Well, what does that look like? It should be issued pursuant to that guidance rule that we're discussing and working through. There should be standards to it, and the bill should reflect that. And that's why we want to propose an amendment at some point to make sure that that's in the bill before it becomes law.
okay, thank you.
So Cindy, I'm just going to add on top of that, and I think this is more for just a kind of an overall explanatory comment, is that this is very limited. There's immunity or an affirmative defense that attaches, but you have to do something. You have to either disclose it properly and follow the appropriate process, or you have to get a written, the proposal would be a written guidance from the commission. And so it demonstrates that somebody is trying to do what they should to take care of or address a concern.
Yes. Yes.
So that if they're trying to do that, then it provides them with protection. It's actually very similar to the advisory opinion request, the immunity that attaches with that.
It also we think it'll have the effect of encouraging people to follow the rule. That yes, if you're following the rule, you get this protection, so please follow it.
Okay, good. Thank you.
But Cindy, I'll be honest, I had my ears went up the same way when you hear that language, right? Because immunity is a big word. And so I understand the concern.
Thank you.
I think there maybe could have been better language to
Well,
describe it.
It's
but-
really an affirmative defense. It's an evidentiary issue that it's a fact issue that will be determined by the prosecutor, or if it's charged out, then they have to do the fact analysis of whether somebody actually did follow the rules. So that's a fancy legal way, I guess, of saying that. It depends on the situation and what the facts are, but it's just you just don't get immunity by it being in the law. It's very fact dependent.
Okay, any other questions?
Logan, I think
Yes, Ron.
you should explain affirmative defense. Because attorneys know what it is, but lay people don't.
Yeah. Okay, I'll give it a shot, Ron. And I didn't practice
Maybe
criminal
Ron
law,
should
but
explain it as the retired judge.
the way it works is if you're charged with a crime, you can use an affirmative defense, meaning the law provides these certain protections, and I complied with the protections as outlined in the law. Here are the facts of how I did that. Jury, please do not convict me. You argue it to the jury, essentially, if you have to. Usually, when a prosecutor is reviewing those things, the prosecutor will take into account when they're deciding whether or not to charge somebody with a crime, whether there'll be an affirmative defense at trial, if it's something that it's even worth going through the process of charging out and prosecuting somebody for. And if the facts indicate, yes, they have a really good affirmative defense, usually a prosecutor is not going to charge them in the first place. So it all goes into the analysis, but if you really need the affirmative defense, it's usually presented at trial, but it probably won't get there in most circumstances. Is that helpful, Ron?
Well, yeah. What I'm saying is, or what you're saying is the affirmative defense is raised by the person that is complained against,
Correct.
and not necessarily just raised by the prosecutor. It's raised by the person who's the subject of a complaint.
Yep.
I took it as, when I read the background, an affirmative defense, would that be something like if a legislator or whatever, if a person follows these steps and follow those appropriately, and then there still was a complaint, the affirmative defense would be, well, I followed the steps, so I complied.
Yes, but it has to be, they have to let you know that they complied.
Yes.
And I want to be very clear, we're talking about a criminal complaint,
Yeah.
not an ethics complaint.
Yeah.
So if it's charged out criminally, they would have to provide, so what they'd have to do is provide evidence that they talked to one of us and they complied with the written guidance that the commission provided.
Okay.
Well, I hated to throw a wrench into this, but I know that sometimes people get confused as to what that is.
Mm-hmm.
No, that was good. Any other questions, discussion?
Ron, this is Murray. That was a good point because in subsection 3 of 1, an individual is immune if, and then in section 2, it goes to the affirmative defense. And it's kind of, I thought it was kind of unusual that if you do it a certain way, you're immune, but if you do it another way, you have to plead it as a defense, an affirmative defense. I'm still trying to grapple with that, but
Murray, we had a thought, and it's just a thought, but it almost seems to me that they should be the same. That they should both have to be pled as an affirmative defense. But that maybe isn't the intent of it. Something that we will likely have a discussion on in the next few weeks.
well, there must be a reason for it, but I don't understand what the reason is. But
We noted that too, Murray. I guess our conclusion was the effect of it, whatever word they're using or how they tee it up, it's going to be the same. Either way, you shouldn't be convicted of it because you complied through one or two. It's just the procedure for that once you get to court, if you get to court, is going to be different. We're not sure why they did it that way, but we didn't see it as a big issue as far as the commission is concerned.
So with that, as the bill is currently, the form the bill is currently in, I do believe the commission needs to oppose the bill. But what we are hoping to do is have an amendment that is in line with the discussion that we've had today and in the spirit of the concerns that we've raised, that fixes those concerns. And so I'm requesting authorization to take that position, that if it stands as it is, we will oppose. If there is an amendment that we can work with the legislature on to have that in line with the spirit of our concerns, that then the commission can support House Bill 1505 with the amendments.
Okay, so I will entertain a motion to authorize staff to support HB 1505 with amendments in line with our discussion today.
I'll make
So
that
moved.
motion.
Oh, second.
Okay, we have a second. Any other discussion? Okay, then Rebecca, will you help us take the roll call vote?
Yep, Chair Anderson,
Aye.
Commissioner Goodman,
Aye.
Commissioner Lindquist,
Aye.
Commissioner Kozer,
Aye.
and Commissioner Stagstein.
aye.
Okay, motion carried.
One question, if the 1505 is appropriately amended and they're both in the same committee at the same time, do you think there's any possibility that they may roll it into one bill?
Murray, I do think that there is a possibility that they could be rolled into one bill, just to reduce confusion.
Okay.
Especially because part of 1505 overlaps with 1360. Section 4 is identical. The confidentiality portions would be identical. I think that that's a discussion point that we've had. Yes.
Okay. Should we keep going then, Rebecca?
Good if you are, Dave.
Okay, let's keep her going.
Okay, so with both House Bill 1360 and 1505, these have a direct impact on two of the commission's proposed rules that we have out there that we've discussed previously. And the one regarding informal guidance is directly linked to House Bill 1505 in the sense that hopefully the amendment is in line with this informal guidance rule that we work on. So I'm going to have Logan walk through some of the changes that we've made and improvements, I'm going to call them, to both our draft enforcement process rules and to the draft informal guidance rules. And we got feedback from the commission, I think it was at I want to say the November meeting, on some improvements to these. So the reason that I want to bring these to you is that there is an emergency clause on House Bill 1505. And so if this passes with an emergency clause, then we need to commence rulemaking on both of these rule sets almost immediately. So we want to make sure that we have those ready to go. So with that, I'm going to hand it over to Logan to talk about the differences and what we changed.
I'll start with the enforcement action rules. There hasn't been big changes to these, but just some changes to note. Some of the definitions still needed to be updated to coincide with the 1360 language that we had approved at a previous meeting, so those have been changed to mirror the bill. And then the next change is way at the end of the document. The last proposed rule, effective rules on pending matters. So when the new process is implemented, the commission is still going to have complaint matters that are pending that we will no longer have complaint rules to follow to conclude and resolve those complaints. So they will have to convert over to the new enforcement action process. So that's what this rule says. On the effective date of the amendments to the rules, the matters pending will follow the procedures outlined in the new rules, and we will notify any respondent who is currently involved with a complaint that these things will move over to the new enforcement process. We will notify them right away so they have a chance to potentially settle their complaints with the commission before an alleged violation is even issued. And that would actually help us potentially close out a lot of complaints that are pending before the commission. So just so we're prepared when the time comes to do that and get ready for it. That's the change to the enforcement rules. What's missing currently from these enforcement rules is the service of documents. So the reason we didn't include how we serve a respondent in the rule, and this kind of goes back to the hearing process as well, is because the commission currently has a proposal in its budget for a case management system. Now, if the commission gets money appropriated for a case management system, that makes the service process much easier. We'll just make a rule that says service, apart from the first alleged violation, service will, going forward, is made through that system. Please sign up for an account, and then you get your documents served electronically on you through the case management system. Now, if the commission doesn't get money for a case management system, we'll have to reevaluate that, and it may be a service through email if they waive it. It makes it a little more complicated, but we'll get rules or draft additions to these rules ready for either scenario, so we're prepared if the emergency clause carries. But it's currently not in there. We're kind of seeing where things go with the budget in the coming weeks, but that's what's missing. So just to note that for future reference. Then turning to the informal guidance rules. These rules also have not changed much except for the commission review provision at the bottom of page 1 and on the top of page 2, and how the commission approves that informal guidance with the idea that we won't be having regular meetings to do this like we do with the advisory opinion. So what does the process look like to do that? And what we came up with is delegating it to the executive director, but then before the informal guidance goes out to the person requesting it, it is sent to the commission, so you can have 48 hours to review it. And then if a commissioner wants to have a meeting to address it, That commissioner should notify the chair, who can call a special meeting before the informal guidance is issued. Now, that's only if a commissioner has a problem with it. The rule goes on to say that if no disagreement is brought up within that 48-hour period, the informal guidance is considered approved by the commission. So silence is consent under the rules to what the informal guidance says. So that's the solution we came up with.
Get feedback on
So we
that.
don't have to go back. I think the previous rule said that if the commission disagrees with it, we can reevaluate it. It was messier, so this is what we thought would work better. We weren't sure about the time period. We thought 48 hours was a good time frame for the commissioners to review it, because we know you all have other obligations and can't look at your state email every hour of the day. So we thought 48 hours would be good for you to have time to review it, but also to make sure that we get guidance out in a timely manner when people have concerns that they need to act on.
So the goal, I'm just going to add, I'm going to link this guidance with House Bill 1505. The goal is that instead of having language in 1505 that says informal advice from a staff member of the Ethics Commission, that it is written guidance in accordance with these rules. Then if somebody acts in accordance with that, that creates the affirmative defense. So it's these rules that guide that particular section of House Bill 1505. We took a stab at 48 hours too. It could be shorter, or it could be longer. I think a lot longer might be too long, but
And
we'd be open to hear
yeah,
comments.
we didn't know. We figured you as the commission would know better on how often you can look at your email, or if we send out a notification via text that, yes, there's informal guidance for you to review. Please let the chair know if we need a special meeting, something like that. But the time frame, we'd like to hear your thoughts.
Okay,
If
any
you don't have
questions?
it, that's fine too.
No, I mean, it makes sense. Yeah. I don't know, 48, I understand it's, yeah,
24 seems kind of tight.
yeah.
And it's something we can amend to as we
Yeah,
go.
we can
If
amend if we
find
need to.
48 hours isn't working, we can go through the amendment process and amend the rule to change the time frame.
Okay, anything else on that topic? Hey, Rebecca, what else do we need to talk about?
We don't need any, we just wanted to give you guys a heads up on those changes that we have, because we may have to move somewhat fast on these rules in order to get in line with statutes that are enacted if there's emergency provisions on them. There's nothing that the commission needs to do now. What we would do in the future is that if an emergency clause passes on either 1505 or 1306 or whatever form it becomes, then we would have all of this ready to go into the rulemaking process. And then we would present that to the commission and get a vote. There is a process to do emergency rules under the Administrative Agencies Practice Act, but it's not likely going to apply.
I don't think this situation will meet that criteria. So if the emergency clause carries, there may be a month or two or three where we have our current complaint rules, but we have new statutory direction or laws. So there might be a transition period, I guess is what I call it, before the new rules are in place. But we'll monitor that as it moves to the legislature. But we'll have the notices and everything ready to do the rulemaking process if it looks like it's going in that direction.
So you're saying you'll probably generate the rules simultaneously if you know where the bill's going?
Yeah, I think I advise the commission to wait until both chambers have passed it, and if the governor, once it's on the governor's desk or after he signs it or does.
Oh, so you wait till it's actually there.
Make sure it's law before we use the funds to notice the rulemaking.
Yep.
But
Oh, yeah.
once we do that, the process is pretty straightforward, and I think it'll be fine. It'll work out.
Any other questions about the draft rules that could be or are impacted by legislation? Dave, hearing none, that is what we had on the agenda today. We will take the direction of the commission on 1505 and get to work.
Okay. Thanks, Logan and Rebecca, for putting this together quickly and organizing it so well and describing it so well. So I appreciate that.
Our job.
And since
Do you
our topics, go ahead.
do you make the intern wear a tie every day?
No, but we testified today.
Oh,
We
I
were in
see.
a committee hearing today, so.
Okay,
I
so
think
he
it
has
was
to
Logan.
look good. He has to look
Yeah.
good then. All right.
Yeah. Yep, Logan testified for the first time today on behalf of the commission. So, but we can't go outside our,
Briefly,
yep, briefly. Sorry. I don't want to go outside our dictates of the special
Well, it
meeting,
relates
so.
to commission work. So
It does.
It's on
However, However, they never asked Logan a single question. So it really doesn't count.
Yeah. I got in and I got out pretty quickly, Murray. Was happy for that.
Okay, since we've covered all the topics of the special meeting, I guess then we are adjourned.
Thank you, folks.
Okay,
Yes.
yeah,
Thanks,
Bye,
everybody.
Thank you.